This is the web transmission service of the Royal Canadian Military Institute. On February the 15th, our Defense and Security Studies program hosted a panel of retired Lieutenant Colonel Rory Fowler and Preston Lim, Judicial Law Clerk at the Court of Appeals for Ontario, who spoke on global military law landmarks in the March to Justice, moderated by Dan Eustace, our Director of Defense and Security Studies at RCMI. Gentlemen, over to you.
Good evening. So I'm Dr. Daniel Eustace. I'm the Director of the Defense and Security Studies program at the Royal Canadian Military Institute in Toronto, and also from wherever you are sitting. I welcome you to the second Defense and Security Studies program speaker event of 2022. Which is entitled March to Justice, Global Military Law Landmarks. Now, last month, our speakers were Vice Admiral retired Mark Norman and Dr. Steve Seidemann, and they discussed a variety of ideas and issues around civilian control of the military. This evening's presentation will not necessarily touch on that directly, although it may, because I have no pretensions of restricting whatever our speakers are going to address. But I suspect that it's going to build on that conversation, but from the perspective of exploring important cases in military law. Now, one of the important facts is that the title of tonight's event is also the title of a new book by that same name. And we have two of the contributing authors, Lieutenant Colonel retired Rory Fowler, who you know well. He has contributed to our program previously, and we thank him for being willing to return again. And a new speaker, someone named Preston Lim, and I'll introduce both of them very shortly. Unfortunately, one of our previously scheduled speakers, Dr. Pascal Levesque, was not able to be with us tonight due to a last-minute scheduling conflict, but we are in great hands with both Rory and Preston. So let me first of all start off by giving a brief introduction to both of these gentlemen. Rory, who you know, is a retired lieutenant colonel who served in the Canadian Forces for nearly 28 years. He was an infantry officer to begin with PPCLI, and subsequently as a legal officer with the Office of the JAG. And in that latter role, he worked extensively in the area of public and administrative law, both as a legal advisor and educator. Throughout his service, he developed a keen interest in the nature of the Crown-soldier relationship and how it was distinguishable from more traditional employment paradigms, and how this unique constitutional and statutory relationship could be and should be better explained and understood. His interest in this subject is driven by a desire to ensure that the governance of the Canadian Forces reflects a just and fair approach to decision-making and complies with the rule of law so that discipline, efficiency, and morale of the Canadian Forces support its overall operational effectiveness. Now, since embarking in his private practice in 2017, Rory has been very, very busy. He's a commentator on national television, radio, and print media, and they often call upon him for commentary on legal issues pertaining to the Canadian Forces and military law in general. So welcome tonight, Rory, back again to the RCMI, if virtually only again, but I think we're going to get close to the long bar very, very soon from what I'm hearing. Now, having said that, I'm very pleased to present a speaker that has not talked to us previously, Mr. Preston Lim, and Preston is currently a judicial law clerk at the Court of Appeal for Ontario, and as he reminded me, that's just down the street from where we normally operate out of. So he's really like a neighbor. So we welcome Preston as well. Preston's background is very impressive. He holds a Bachelor of Arts in Near Eastern Studies from Princeton, a Master of Global Affairs from Tsinghua University, where he studied as a Schwarzman Scholar, and he holds a JD from Yale Law School. He previously served as a policy advisor to the Honorable Erin O'Toole. He writes regularly on Canadian foreign policy, constitutional law, and military law. His book, The Evolution of British Counterinsurgency During the Cyprus Revolt, 1955 to 1959 was published by Paul Grave Macmillan in 2018. And Preston, you and I will have to chat about counterinsurgencies. That's something I've written on as well. Now, Preston contributed to the chapter in the book we're talking about tonight, which was entitled Progressive but Definitely Not Revolutionary. This is something that he's going to talk about in his presentation. It's a particular judgment in the United Kingdom. So this is going to discuss not only Canadian case law relevant to military issues, but internationally as well. But here's the other thing. I was told earlier today that Preston is going to clerk for the Chief Justice of Canada later on this year. And so we really need to keep watch on this young man's career going forward in the future. And we're going to keep our eye on him for sure. Now, with respect to the order of march, Rory will speak first, followed by Preston, and then followed by Q&A. Please feel free to ask about any aspect of law that you may be interested in. We have two experts here, obviously. Things like, let's say, the Emergency Act, hint, hint. That seems to be something on the front page news today. Now, before we begin, I would like to ask Mr. Frank Rosenblatt to speak. He is one of the editors of the book. I was an author and an editor. I'd want to sell copies of this book. So I'm sure we're going to indicate at some point in time how you can acquire one. Everybody needs one of these on their shelf, because even if you don't read it, it's going to make you look really, really smart. I've got a whole bunch of those books on my shelf.
Hey, hello, everyone. This is Frank Rosenblatt, and this is our book, A March to Justice, available at your local bookseller. And a lot of people have asked me what this book is about. And the main thing that I think of is that this is a book about friendship. That Navdeep Singh is a lawyer in India, and I'm a guy in the United States. I'm not a really sophisticated international guy, but we came together because we found a lot of things in common, and not just between us, but by 25 other authors who contributed chapters to this book, including our good friends Rory and Preston. We realized that we had some things in common. Just as the international human rights has taken hold and given a common language to people around the world, we found that there are strains of that when talking about the military. There are certain things that we have in common with people from other countries. We believe in our country. We are patriotic. We are nationalists for our country. Many of us have served in the military. And for those who haven't served, they still contributed too, but we've recognized that national militaries are an essential institution for our countries. We are a believer in human rights and the sorts of fundamental freedoms, and we have that in common. And yet we often tend to challenge the myths and shibboleths given to us by those in power in the national military. We believe in civilian control of our militaries, and we believe that our institutions should be resilient enough to be able to withstand strain of domestic disturbances. And finally, we believe that our militaries have a proper role to play in impartial and independent tribunals when they need to adjudicate disputes, and yet they defer to the civilians when necessary. So with that story and friendship, everybody please greet me join me in greeting Navdeep. It's 5:30 in the morning in his time, but I know he cares enough about this important panel in Canada to be part of this. Most importantly, we're here for our friends tonight, Rory and Preston, and their important contributions. The world looks to Canada in Généraux and the important developments in the Canadian military and the relation of the Canadian military to its government and society and the international stage. We're all looking to you. The Canadians are an important part of this book. And so without further ado, Rory, thanks for putting this on, and over to you.
Thanks very much, Dan, and thanks as well to Franklin, and thanks to Preston, who's filling in for my colleague Dr. Pascal Levesque at very short notice. And Preston, as Dan's already mentioned, is presently clerking at the Ontario Court of Appeal, which is an extremely busy position. So I'm very thankful that Preston was able to fill in at the last minute. I'm going to keep my remarks relatively brief, probably even briefer than I intended and briefer than I normally do. So hopefully you were all sitting when I mentioned that, because that probably came as a shock and a surprise to those who know me. I'm going to talk very briefly about Genereux, and Genereux very much is a landmark decision for military justice, but we also have to remember it's over 30 years old at this point, or about 30 years old at this point. And it's starting to get dated. And as you'll find out when Preston talks about the far more recent case of Stillman before the Supreme Court of Canada, in many ways, Stillman has eclipsed Genereux. But there are still some very important facets from Genereux that stay with us and frankly inform the current debate with respect to the independence of the military judiciary, a topic that was recently a focus of judgment by the Court Martial Appeal Court of Canada this past summer in 2021. So briefly, Genereux was a case in which an individual, a member of the Canadian Forces, was prosecuted for an offense under the Controlled Drugs and Substances Act. So not technically a criminal offense, it wasn't from the criminal code, but it was a civilian offense under an act of parliament. Yet Genereux was prosecuted, he was a sergeant, he was prosecuted under the Code of Service Discipline for what is essentially a civilian offense. And what lay at the heart of the issue in Genereux was whether or not courts martial, as they were constructed at the time, and there have been some significant changes since then, but the central issue was whether or not courts martial were sufficiently impartial and independent that Genereux would get a fair trial, just like he would get before a civilian court. And what's particularly interesting about the Genereux judgment is that it is consistently cited by both the Judge Advocate General and the legal officers in the Office of the Judge Advocate General, as well as very specifically the Director of Military Prosecutions, for standing for the proposition that the Code of Service Discipline, as a separate derogation from civilian justice, is a valid and compliant with the Charter and a valid expression of law within Canada. But what's interesting is that was never actually at issue in the Genereux decision. And a compelling argument can be made that the far more recent case of Stillman from 2019, which Preston will be discussing, actually is a more compelling example of the constitutional validity of the Code of Service Discipline as a derogation from the civilian justice system. But I'll let Preston talk about that. What I'm going to talk about is Genereux. And at its heart, even Genereux conceded, and Genereux's counsel, who's now an appellate judge, Genereux conceded that the Code of Service Discipline represented a valid expression of law. And so the discussion in Genereux that is often cited by the Office of the Judge Advocate General and often cited by the Director of Military Prosecutions is really something that we lawyers call obiter dictum, or a statement that is not directly related to the central theme of the case. And in fact, that was never truly at issue. What was at issue was whether or not courts martial, and specifically a general court martial, because that's what was at issue in Genereux, whether a general court martial was sufficiently independent and impartial for the purposes of rendering justice. And what's interesting is in that matter, on that issue, the Crown actually failed. The majority, all but one judge, Justice Leroux-Jubé, found that courts martial were not sufficiently institutionally independent and not sufficiently impartial to render a fair verdict. That then led to, along with various scholarship that had been conducted in the 1990s, the significant changes that were introduced in Bill C-25 in the late 90s, which was enacted and came into force between 1998 and 1999. And so what Genereux really was a catalyst for significant changes to our court-martial system that in many ways brought that system much more in line with civilian standards. And so one of the themes of these presentations over the next few weeks, the next few months, is the interplay between the civilian jurisdiction and the military. And one of the things that Genereux laid the groundwork for that was then carried on with Bill C-25 in the late 1990s was the increasing, what some people would characterize as the civilianization of the Code of Service Discipline, the incorporation of civilian norms of justice, including the independence of the judiciary. But one of the things that Genereux did not address, and one of the central themes of the chapter that I and my co-author, Afton Maisonneuve, contributed, was whether or not courts-martial are actually representative of the judicial branch of government, or whether they're representative of the executive. And this is what we characterize in our chapter as the path not taken. So we describe it through an analogy of coming to a fork in the road, and the path that wasn't taken was an examination of whether or not courts-martial are properly characterized as an extension of the judicial branch or properly characterized as an extension of the executive. And what's interesting is all three judgments, and there were three judgments in Genereux, one by the majority, 5 judges, one by a concurring group of judges, 3 judges, and a dissent by Justice Leroux-Jubé. So Leroux-Jubé was the only one that held that courts-martial, as they were configured in the early 1990s, were sufficiently impartial and independent to serve the needs of justice. The other 8 judges all held that changes were necessary in order to achieve that independence. All 3 of those judgments were predicated upon scholarship by a legal officer from the 1970s. So a gentleman by the name of James B. Fay, who was a serving legal officer at the time, published a rather comprehensive dissertation in 1975 that dealt with military justice. And what was interesting is all 3 of the judgments relied upon essentially the same argument that Jim Fay had presented, even though they came to slightly, and in Justice Leroux-Jubé's case, significantly different conclusions. And one of the central propositions that Jim Fay had presented was that although having a military officer preside over a court-martial in a role that was then described as a judge advocate and is now described as a military judge, although having a serving officer serve in that role to an extent eroded the impartiality and independence of the position, that it was important that the individual possessed legal acumen as well as military knowledge and military acumen, and that military knowledge and acumen offset any diminishment in the independence and impartiality of the position. What Jim Fay also recognized is, as a serving officer, that presiding judge advocate was very clearly a representative of the executive. So one of the central tenets of his thesis was that courts-martial were presided over by somebody who was representative of the executive. Much like our colleagues in the United States and in Australia, where their military tribunals are viewed as being an extension of the executive and not encapsulated within their judicial branch. Jim Fay's proposition in 1975 was that courts-martial were an extension of the executive. And we have to remember, 1975, that predated the charter, whereas Genereux was decided 10 years after the charter came into force. And what was interesting is, in none of the judgments in Genereux did any of the judges actually come out and expressly state that, yes, courts-martial are firmly in the realm of the judicial branch or firmly within the realm of the executive. And in all 3 judgments, there were indications that essentially the presiding judge advocate, what we now view as a military judge, had 1 foot firmly in the executive camp and 1 foot firmly in the judicial camp. And they never really resolved that ambiguity. So when we fast forward to the present day, many of you may recall back in throughout 2020, there were a series of judgments in which military judges were being asked to rule upon whether or not they were sufficiently independent from the executive to satisfy the requirement for an independent and impartial tribunal under Section 11 of the Canadian Charter of Rights and Freedoms. And successive military judges all held that because they were subject to direction from the Chief of the Defense Staff in certain aspects of their duties, and because they were still serving officers in the Canadian Forces, they lacked sufficient institutional independence. And this came to a head in the fall of 2020, when many of those judges, 3 of them in particular, started staying significant prosecutions. That then led to an appeal that was heard by the Court Martial Appeal Court of Canada, actually a series of appeals, but the key appeal was heard in the case of the Queen versus Leading Seaman Edwards and others. And in that judgment, the Court Martial Appeal Court of Canada held that no, in fact, military judges, notwithstanding that they are serving officers, are still sufficiently independent to serve as military judges. But one thing that was still not resolved, I would suggest, in the Edwards case before the Court Martial Appeal Court of Canada and in the subsequent cases that the court heard, was whether or not courts martial are properly considered to be constituted within the judicial branch or properly constituted within the executive branch. So we still have a circumstance where military judges have one foot in each camp, and whether or not that ambiguity is sufficient to satisfy us as to their independence remains an open question, because various accused in the Edwards and Crépeau decisions have sought leave to appeal before the Supreme Court of Canada. Now, we don't know whether they're going to be successful. The judgment from the Court Martial Appeal Court of Canada was unanimous. Therefore, they don't have a right of appeal before the Supreme Court of Canada. But we do know that they have sought leave to appeal, and that is currently being considered by the Supreme Court of Canada. We don't know when that decision is going to be made. And so what I want you to leave you with, because I don't want to get too technical, is we still have some ambiguity within the court martial system as to whether or not our military judges are sufficiently independent to be able to preside. The last word we've got is from the Court Martial Appeal Court of Canada, which has held that they are, in fact, sufficiently independent. Whether or not that goes before the Supreme Court of Canada is another matter. And if it does, we can expect renewed argument with respect to clarifying whether courts martial properly fall within the judicial branch or the executive branch. But I'll leave you with this. One of the interesting aspects of Genereux that I mentioned at the outset is it's often not cited in terms of the independence of the judiciary, because, as I say, that was left as a bit of an ambiguous answer. What it is consistently cited for is representing the argument or the proposition that the Code of Service Discipline represents a valid and constitutionally consistent derogation from the civilian justice system. And what I would suggest to you is that argument doesn't have that much merit in terms of Genereux, because that was never really contested in Genereux. But that's okay, because we have a far more recent judgment in Stillman, which Preston Lim is just going to talk about, that does stand for that proposition in a rather robust manner. So, Dan, thank you for that opportunity, and over to Preston to examine Stillman.
Thanks, Rory. That's extremely interesting, and we'll have an opportunity in the Q&A to sort of parse out what some of the potential implications of what that Supreme Court decision could mean going forward. So we'll leave it at that for the moment, but I'd like to turn this over now to Preston. Welcome, and we look forward to hearing your remarks. So,
thank you so much, Dan. It's a privilege to be able to speak with you all today. I do have big shoes to fill. So Dr. Levesque, who was originally slated to speak, he wrote an excellent chapter on the Stillman case in March to Justice. So I hope that you all get a copy so that you can read firsthand what he had to say on the case. The argument that Pascal makes, and with which I agree, is that Stillman has now become the principal landmark decision in Canadian military justice, displacing Genereux, which is the case that Rory just talked about, of course. I'll explain why I agree. Stillman is obviously a key decision, and it makes clear, first and foremost, that a separate military justice system is constitutional and essential as well to the operational effectiveness of the Canadian Armed Forces. So in my remarks today, I'm going to do three things. First, I'm going to summarize the majority and the dissenting opinions in the Stillman case. Second, I'm going to discuss a couple potential issues that the court in Stillman left open. In particular, the court states that future challenges to the constitutionality of military panels, and these are analogs to civilian juries, challenges to these might be appropriate in the future. Third, I will briefly place Stillman into global context by comparing the case to a well-known and slightly older judgment from the European Court of Human Rights, entitled Martin versus the United Kingdom. That's the case that I wrote about. In March to Justice. And there are three things that I'd like you to take away from this talk. The first one is that Stillman makes clear that a separate military justice system is constitutional, and that service tribunals can try criminal and other federal offenses that have been committed in Canada by those subject to the Code of Service Discipline. The second takeaway that I'd like to convey today is that it is likely that we will see constitutional challenges to the military panel system proliferate. Lastly, full civilianization of the Canadian military justice system is by no means inevitable. So let's get into it. What happened in Stillman? So in Stillman, the court consolidated several appeals from the Court-Martial Appeal Court and heard them all at once. The case revolved around this key question: does the Canadian military justice system contravene Section 11F of the Canadian Charter of Rights and Freedoms? More specifically, the case revolved around two provisions. First, of course, you have Section 11F of the Charter, which guarantees every person charged with an offense carrying a punishment of at least 5 years imprisonment the right to the benefit of a jury trial, except in the case of an offense under military law tried before a military panel. So the court had to determine what the scope of that military exception was. Second provision we should talk about is Section 130(1)(a) of the National Defense Act. I'm going to assume that most of you are familiar with the basic contours of the NDA. The NDA, of course, establishes the Code of Service Discipline, the CSD. And the CSD itself establishes, in turn, various service offenses. So you'll have offenses such as spying for the enemy, mutiny with violence, insubordination. What Section 130(1)(a) of the NDA does is that it transforms criminal and other federal offenses into service offenses. Thus, under this section of the NDA, service tribunals have the jurisdiction, which they share with civilian courts, to try criminal and other federal offenses that take place within Canada and that are committed by persons subject to the CSD. So let's restate that key question that's at play here. Is Section 130(1)(a) of the NDA consistent with Section 11F of the Charter? Does the military exemption referenced in Section 11F of the Charter validly include those offenses that have been transformed into service offenses by the operation of Section 130(1)(a)? Court said yes. Thus, service members who are charged by military authorities with serious civil offenses that have been incorporated into the CSD and that have been committed in Canada, they're not entitled to a jury trial. Now, of course, they might still be entitled to be tried by a general court-martial, which consists of a military judge and a panel of 5 military members. I'm going to briefly unpack the majority opinion, which was penned by Justices Moldaver and Brown. Now, what they did, among other things, is they discussed the historical evolution of the Canadian military justice system. I'm not going to recount all of that history. It is very interesting, but the main point of that historical discussion is to demonstrate that the transformation through statute of ordinary civil offenses into offenses under military law has long been a feature of both Canadian and British military law. In the Canadian context, the original National Defense Act of 1950 contained a provision similar to the modern Section 130(1)(a). In the British context, you had a similar conversion provision, both in the Army Act of 1881, as well as in the Naval Discipline Act of 1866. Here's the point. When the Charter of Rights and Freedoms, when the drafters of the Charter, articulated Section 11F, they were well aware that service tribunals had jurisdiction not just over purely military offenses, but also over criminal and other federal offenses that had been converted in. Justices Karakatsanis and Rowe, they dissented. They would have resurrected something called the military connection test. In their view, service tribunals are only constitutionally able to try those acts or omissions that are inherently military in nature or are committed in circumstances directly connected to the military. Canadian courts didn't come up with this test themselves. They actually adopted this test from the United States. The United States Supreme Court first introduced the American version of the military connection test in 1969 in a case called O'Callaghan versus Parker. They only got rid of that test in 1987 in a case called Solorio versus the United States. The test was simply too unwieldy, too impractical. US courts had to look to a whopping 12 factors to determine if a particular offense by a service member was service connected. This was a highly discretionary test, and I would argue it imperiled the rule of law. The test just had too many factors. And as a result of that, courts could not and did not apply the test in a uniform fashion. Ultimately, the US Supreme Court decided that it was better to adopt a standard more akin to a bright line rule, a clear standard. In Canada, courts started employing the military connection test in 1980, and courts only put an end to that when the Supreme Court released its 2015 case, R versus Moriarty, in which it held unequivocally that the only military nexus that is required to render an offense a service offense is the accused's military status. So despite Justice Karakatsanis and Rowe's plea to resurrect the military connection test, I think it's safe to say that the majority has nailed that coffin shut, all for the better. I think that it is better to have a bright line standard that can easily be applied by the courts than to have a multi-factored test that gives courts too much discretion. Moving on to the second point. That second point is that Stillman, in many ways, does not constitute a wholesale endorsement of the Canadian military justice system. At paragraph 86, and I'll read this out, the majority wrote as follows: "We would not foreclose the possibility of challenging certain aspects of the military panel system, particularly in relation to their composition and their independence from the chain of command under other provisions of the Charter." The point here, you can be sure that in a future constitutional challenge, an appellant will take aim squarely at the military panel system. Panels are analogs to civilian juries, but they do differ in a number of ways. I'll just briefly lay them out before moving to my third point. A couple of examples. A jury consists of 12 individuals. Panel consists of 5. Panel members are drawn only from the military community, while civilian jurors are drawn from the wider civilian community. Third, military rank structure. That's actually reflected in panel composition. The panel is designed to include a number of the accused's superiors, for example. Finally, panel members are entitled to take judicial notice of all matters of general service knowledge. Obviously, civilians can't do this. Is the Supreme Court going to uphold the military panel system as constitutional? We'll have to see. But I would just guess that given the trend in recent cases to uphold a separate military justice system, I doubt that the Supreme Court will hold military panels to be completely unconstitutional, though they may well hold that certain reforms need to be made to panel structure and composition. Finally, and I'm just wrapping up here, I'd like to compare Stillman to the case that I wrote about in the book, Martin versus the United Kingdom. This was a case before the European Court of Human Rights. Just a caveat before we proceed, we should be wary, I think, of engaging in hasty comparativism. The Canadian military justice system, well, they're unique. And just because other countries and systems organize their justice systems in a certain way does not mean that we need to follow suit. That said, other countries, particularly those that share close historical ties with Canada, can shed light on how to approach questions of reform. So let's dig in. Martin versus the United Kingdom. This was a 2006 case. Mr. Martin was the civilian son of a British soldier. He was living on base in Germany. He murdered a civilian who was working as part of the Rhine Garrison's support unit. He gets convicted by a general court-martial. He appeals that general court-martial conviction to the Court-Martial Appeal Court, then to the British House of Lords, and then to the European Court of Human Rights. Now, the ECHR, the European Court, they hold that only in very exceptional circumstances can the determination of criminal charges against civilians in military courts be held to be compatible with the European Convention on Human Rights, specifically with Article 6, which guarantees the due process of law. The court criticized the fact that all 6 panel members of the General Court-Martial were subordinate in rank to the convening officer, and this raised doubts as to the panel's independence. Here's the point, though. The British Parliament didn't respond to this case by abolishing military jurisdiction over civilians. Indeed, the Armed Forces Act of 2006, this is a major piece of reform legislation, extended the jurisdiction of courts-martial to include serious offenses committed in the United Kingdom, such as murder or manslaughter. The point is that British military tribunals continue to retain jurisdiction over civilians, and that full civilianization of the military justice system does not need to be seen as inevitable or natural, even in a market democracy such as the United Kingdom or Canada. British Parliament, to put it simply, has resisted full civilianization. Now, the Supreme Court's holding in Stillman similarly stands, I would put to you, for the proposition that a separate military justice system is constitutional and essential to the operational effectiveness of the Canadian military. That's all I have. Thanks so much for listening.
Preston, thank you. That was not only interesting, but it was very well explained to someone even like me. Now, my son is a lawyer, but I don't understand him either. But I'm going to get him to call you because I think this is going to help. Now, folks, please enter your questions to these gentlemen. But let me start off because I'm trying to get my head wrapped around a couple of things here that I think apply to both of you in terms of your presentation. So I guess the first question I would have is, what do you think the significance would be of that Supreme Court decision that you are talking about, that pending decision? So for a layman like myself, if the decision is that the military justice system is not constitutional, if that's really what this boils down to, that's going to have significant effect, I presume, on a number of things. I know Preston, you indicated, and I think Rory intimated that's unlikely to happen, but what if it did? What would the implications be for how the Canadian Armed Forces operates today? Thank you.
Right. Well, I'll start by answering that question briefly, and then I'll turn it over to Rory because I know he'll have more to say. The court in Stillman actually addressed this point head on. And I think the practical aspect of your question, Dan, is really important. Because, it's one thing to say in an abstract sense, is this system constitutional or unconstitutional? What are the practical effects of determining the system to be unconstitutional? One of the effects would be that really a lot of these offenses would be shunted off into the civilian system. And one of the things that the majority warns about in Stillman is that this is going to increase wait times for people who are being tried in the military justice system. One of the main objectives, of course, of the military justice system is to provide effective, but also efficient justice. A lot of these charges need to be tried quickly. And so there's the fear, and of course you can bear this out through quantitative study, but there is at least the fear overhanging all of this that to shunt all of the offenses that were discussed in Stillman into the civilian system would create delays and render the Canadian military, as a result, less operationally sound.
So Dan, the issue in the applications for leave to appeal is a relatively narrow issue. It's whether or not military judges, as serving officers of the Canadian Forces and as military judges, are sufficiently independent that they constitute an independent and impartial tribunal for the purposes of Section 11 of the Charter. Now, first, we don't know if the Supreme Court of Canada is going to grant leave. If they do not, then the prevailing judgment will be the judgment of the Court Martial Appeal Court of Canada in the Queen and Edwards and others, in which they've clearly said, in our view, military judges are sufficiently independent, notwithstanding that they are serving officers. Now, my view is, and I wrote a paper last year on it, and there's another paper that's sort of a follow-on paper that we're hoping to publish this year. If the Supreme Court of Canada does accept and does grant leave to appeal and does accept the appeal, there is the potential, and I would anticipate that there would at least be some, if not a majority of the court, that would find that military judges as serving officers are vulnerable with respect to their institutional independence. And I'll point to three specific things that can be harbingers of such a judgment. First, you'll recall that the former chief military judge had been subject to a court-martial proceeding. Now, that failed, and it failed in a rather colossal fashion, but it failed because of a variety of factors, not the least of which is there's a very small pool of judges to preside, and most of them were conflicted out of it anyway. And there are problems with trying to try this senior judge of the Canadian Forces in a court-martial, just as there would be problems if you tried to charge and proceed by court-martial with a charge against, say, the Chief of the Defense Staff, or a former Chief of the Defense Staff, or a commander of a command, right? We've encountered those issues, some of us rather intimately, if you will. So there are problems with certain individuals within the Canadian Forces who could probably never be tried by court-martial. You couldn't try the Judge Advocate General by court-martial. You couldn't try the Director of Military Prosecutions by court-martial, because all court-martial prosecutions are brought by the Director of Military Prosecutions. So you can point to about a half a dozen or 10 officers in the Canadian Forces who could never be tried by court-martial. The second thing I would point to is, not only was the former chief military judge the subject of an unsuccessful court-martial prosecution, but on the 20th of March of this year will mark 2 years that we have not had a chief military judge. Right? We will have gone 2 years without having a chief judge. No other jurisdiction in Canada has gone longer than a couple of months without having a chief judge or chief justice. And one could point to that saying, well, what's the motivation of the governor and council in not designating a chief military judge? What
do you think that is?
Personally, I think it's just laziness on their part, but it could be a signal that they're waiting to see which judge finds favor with them, that it's a way of influencing the serving military judges, because we have to remember that 3 of the 4 current serving military judges all held that they weren't sufficiently independent. They all stayed prosecutions, which caused a great deal of consternation, right? And the reality is there is scope for military judges as serving officers to be adversely influenced by the chain of command, much as the former chief military judge was. And you don't have to necessarily point to mala fide motives. You just have to point to the fact that they are vulnerable, and the reasonable person, the test is, what would a reasonable person, informed of all of the context, would that individual view the military judge as being sufficiently independent? And I think there's scope for the reasonable person to find that they are not. But I'm not going to suggest that the sky is falling and the code of service discipline will fall apart. Because every now and then one of these challenges comes along. It happened in 2018 with Beaudry. It happened in 2020 when the prosecutions were stayed by military judges as a result of findings with respect to their independence. And people will come out and say, well, that's it then. The code of service discipline is falling apart. I wouldn't suggest that would be the case, because there's actually a relatively simple solution for the Supreme Court of Canada if A, they hear the appeal, and B, a majority of the judges find that military judges, by virtue of being officers in the Canadian Forces, are vulnerable to influence that would adversely affect their independence. Because what we're really talking about here is Section 60 of the National Defense Act. And specifically, under subsection 60 sub 1, all officers and non-commissioned members of the regular force, which includes the 4 military judges, they are all officers of the regular force, are all subject to the Code of Service Discipline. It is that factor, the fact that military judges who preside over courts-martial are also subject to the Code of Service Discipline, that can potentially undermine their independence. The simple solution for the Supreme Court, if they were to hold that that provision makes military judges vulnerable, is to simply hold that Section 60 sub 1 has no force or effect in terms of military judges.
Mhm.
That would allow courts-martial to proceed. It would ensure the independence of the military judiciary. It wouldn't cause the Code of Service Discipline to grind to a halt. And it would allow Parliament to respond within that dialogue that exists between Parliament, between the legislature and the courts, to come up with a different solution. And I would suggest that if that appeal does proceed, and if the majority of the Supreme Court of Canada does find that military judges lack sufficient independence, it will be because of subsection 60 sub 1. And I anticipate that their likely course of action would be to hold that it will not apply to military judges until and unless Parliament comes up with greater safeguards for their independence.
Preston, do you have something you want to add to that particular discussion?
No, I think Rory hit that great. So maybe
Okay.
let's move on to the next question.
Okay, so a couple of things come to mind for me. So, one of the things that certainly came out in the last several months, if not the last couple of years, has been the whole question of harmful and inappropriate sexual behavior in the Canadian Armed Forces. And there was a call, and there is still a call, that all of any or all of the cases involving that issue ought to be moved to civilian jurisdiction, because it felt that there's no possible way that those cases can be handled appropriately within the context of military justice. Can I just get some views on that before we move on to some other questions? Preston, you want to take a wrangle at that one?
I'll let Rory start, and then I'll buttress after.
Okay.
Okay, so what we know from what Preston explained quite succinctly is that as a result of Stillman, all sexual criminal offenses fall within the jurisdiction of the Code of Service Discipline. So as a matter of law, we can exercise jurisdiction. As a matter of policy, if, for example, the Minister of National Defense didn't want criminal offenses of a sexual nature, for whatever policy reasons, to be prosecuted under the Code of Service Discipline, it's open to the minister to direct in an indirect fashion that would happen. And I've actually commented on this before in my blog. And at the end of the day, what you're talking about is two separate sets of direction, which do not necessarily flow directly from the minister to the affected party. So what you're really talking about there, Dan, are two separate factors. One is the investigation of criminal offenses of a sexual nature, which is done by not just the military police, but specifically the Canadian Forces National Investigation Service, the CFNIS, and then the prosecution by Director of Military Prosecution before the courts martial. So what would have to happen for that policy to come to fruition, and quite frankly, I haven't seen these directives publicized, is the minister does not direct the Canadian Forces Provost Marshal to do so. The minister does not direct the Director of Military Prosecutions to change their policy. What would have to happen is the minister would have to issue direction to the Chief of the Defense Staff, who would then issue direction to the Vice Chief of the Defense Staff, who would then issue direction to the Canadian Forces Provost Marshal with respect to policy for the investigation of such offenses. And the default for such direction from the Vice Chief of the Defense Staff to the Canadian Forces Provost Marshal is that it will be made public. I have not seen that happen. With respect to prosecution, again, the Minister of National Defense can issue direction to the Judge Advocate General, who would then be required to issue direction of a general nature to the Director of Military Prosecutions. And again, the default is such direction must be made public. So that policy decision could be made. it would have to flow from the National Defence Act, because Parliament has spoken very precisely about how that direction should be issued to both the Canadian Forces Provost Marshal and the Director of Military Prosecutions. The corollary to that is, what would be the outcome? And we're probably already starting to see some concerns arise, because some of the matters that have been investigated by the military police have been referred to civilian prosecutors before civilian courts of criminal jurisdiction. And what we've already seen start to happen is a bit of a disconnect between those civil authorities and the military authorities. The military authorities have very little visibility on the prosecution. They have very little visibility about how the accused, who's a member of the Canadian Forces, is being dealt with in the civilian system. And where the complainant is also a member of the Canadian Forces, they have equally limited visibility with respect to that. And many commanding officers have concerns. If one of their subordinates is a complainant, they want to be able to take appropriate action to protect that complainant from any reprisals or from having to run into the accused or the respondent in that case, because in some cases, they're from the same unit or the same formation. And so once you start referring matters to civilian prosecutors, particularly if you don't have very clear policy direction in place, the commanders who are still responsible for not just the discipline, but as we know from cases like General, they're responsible for the discipline, efficiency, and morale of their subordinates. If they lose some familiarity with how the process is unfolding in the civilian jurisdiction, that will impair their ability to ensure that they can maintain the morale of their subordinates as well.
Okay, all good points. Preston, you want to weigh in on that at all?
Yeah, I'll just add on to that a little bit. And the point that I'll get across is that it shouldn't have taken the crisis this year and this last year to demonstrate issues in the Canadian Armed Forces with regards to sexual offenses. And what I mean by that more specifically is that, at least in my opinion, there's a very robust existing external review process, whereby every couple of years, you have an independent authority. And the most recent one, of course, was conducted by Justice Fish, who was a former Supreme Court Justice. And his third independent review authority report, which was recently released, had talked about sexual offenses, how they're prosecuted, suggested reforms. Years before, in 2015, Justice Mary Deschamps, who was also a member of the Supreme Court, she conducted an external review into sexual misconduct and sexual harassment in the Canadian Armed Forces. The point here is that a lot of the reform ideas had been percolating for several years. And I think while it's easy to maybe point the fingers now and say, look, why weren't these reforms implemented at an earlier stage? Parliament bears at least some blame for the slowness of reform here. They had a lot of these recommendations. They failed to act on these recommendations by passing legislation that would have enacted these reforms directly. And so, I think looking forward, it's very important to underscore the importance and the heft that these independent review authorities bring to the table. These are often very sensible reforms, and Parliament needs to get on them quickly if we want to ensure that the Canadian military justice system and the Canadian military more broadly are reform compliant.
Okay, let me bring this up to February of 2022. In the last 24, 48 hours. So a couple of interesting things have happened, right? First of all, we've discovered, or public has discovered, that there are members of the Canadian Armed Forces who have evidently been somehow involved or supporting these trucker convoys / occupations, whatever you want to call them, on the one hand, and on the other hand, we now have the imposition of the Emergencies Act. Preston, you talked about the idea that civilians evidently can be tried within the context of the military justice system, but we don't do it or can't do it as it's currently constituted in the context of the Canadian system. Maybe I misunderstood that. But in any case, what happens to these folks? So let's say that some of these folks are found to have been actively supporting these protests. And, there's evidence that, they have been actively providing whatever, either material support or operational planning support or, logistics planning or whatever the case may be. What happens to those folks? And does the imposition of the Emergencies Act change what could potentially happen to them going forward? It seems to be a rather complex joining together of different things happening simultaneously. Maybe I don't even know what I'm talking about, but I just sense that this could be a complicating factor somehow. So whoever wants to take that, please feel free.
I'll jump in, Dan, if Preston doesn't mind. That's a polycentric question. That's an incredibly polycentric question. So I'm going to start with some comments based upon some of the things that I've seen on social media, because there's some misconceptions, some significant misconceptions out there. So first off, with invoking the Emergencies Act, and specifically it's under Part 2 of the Act, which deals with a public order emergency, that does not create martial law. Okay, so people comment about how, oh, now it's martial law. That is fundamentally not martial law. So martial law is often defined as typically the temporary substitution of military authority over civil authority. That's not the case. So the military remains in Canada subordinate to civilian control. This is not martial law. More importantly, invoking the Emergencies Act does not automatically engage the Canadian forces, right? It does a variety of things, but it doesn't automatically engage the Canadian forces. And the reason people might think that is because the last time that similar legislation, the War Measures Act, was invoked in 1970, the military was also called out under aid of civil power under the National Defense Act. So you've actually got two separate federal statutes that are relevant. The third comment that I'm going to make before I get into a couple of more detailed points, Dan, is people say, well, this is the end of democracy. Well, no, it's not the end of democracy. Because first, the Emergencies Act is valid legislation that was passed by Parliament, right? So the executive, the government, is relying upon lawfully enacted legislation that was enacted by a lawfully elected Parliament. Secondly, the Emergencies Act has very robust supervisory role for Parliament. So a motion relating to the emergency must be tabled before Parliament within 7 sitting days, and Parliament is sitting presently. So it has to be tabled within 7 sitting days, which will be next Monday, for Parliament to vote on, and Parliament can revoke the invocation of the Emergencies Act, right? That is the parliamentary supervision under Part 6 of the Act. So when people say it's martial law, they're wrong. When they say this is the death of democracy, they are wrong, right? It's not even open to debate. That's not the death of democracy. Nor does it include necessarily involving the armed forces in any way, shape, or form in the enforcement of any public order emergency. Okay, so that's the initial comments that I want to offer. With respect to your specific questions about members of the armed forces who may be involved, it's a polycentric question because it depends on the nature of their involvement. Suffice to say, certain things are relatively clearly a contravention of the Code of Service Discipline or a contravention of a directive, regulation, or order for the governance of the Canadian Forces, which would lead to potentially a Code of Service Discipline offense. So the first thing I'm going to say is, I don't presume that anybody's guilty. In fact, I'm a defense counsel. I start with the presumption of innocence. Okay, but if somebody may have contravened the Code of Service Discipline, and I'll give you an example. I won't speak to any specific case, but it's something that's going to be foremost in a lot of people's minds. There have been some videos made by members of the Canadian Forces while in uniform talking about controversial public policy issues. There is a QRNO provision, QRNO Article 19.36, specifically paragraph 19.36 sub J, that prohibits a member of the Canadian Forces from publishing, giving a lecture, or otherwise broadcasting commentary about public policy of a controversial nature. That prohibition is a valid expression of law. It's a ministerial directive. Contravening that prohibition is a potential code of service discipline offense, at the very least, under Section 129 of the National Defence Act. A charge could be laid based upon a validly conducted investigation that gathers sufficient evidence to support such a charge. And I'm not presuming that that has necessarily been done. What I would suggest is, if an investigation is conducted, a disciplinary investigation is conducted into a matter such as that, it is important that that investigation be conducted efficiently and not take several months, because there's probably little justification for taking that long. And if there is sufficient evidence to support the laying of charges, I would suggest that it is a more appropriate course of action for the Canadian Forces to proceed under the Code of Service Discipline than to attempt to proceed under administrative measures. And there's three reasons why. The first reason is, if you proceed under the Code of Service Discipline, it is transparent, it is public. If you proceed administratively, you're dealing with personal information, it is not transparent, it is not public. When the alleged wrongdoing is very transparent and very public, it requires a similar response. Second, the Code of Service Discipline has robust protections for an individual accused of such wrongdoing, including potentially trial before the independent judges that we've been talking about this evening. The accused would benefit from representation by defense counsel, as well as a robust prosecution by the Director of Military Prosecutions. And the third reason is, if the chain of command perceives such alleged misconduct as being very serious misconduct, it warrants being dealt with under the Code of Service Discipline to use the appropriate tool for the maintenance of discipline, efficiency, and morale, which we know from Genereux and we know from Stillman, in a manner that reflects the seriousness of the alleged offense. If they proceed administratively to deal with these matters, I would suggest they would undermine the credibility of the Code of Service Discipline.
Okay, so just to help me understand this a bit further, so let's say, for example, that some of the folks, it's not unlikely, but some of the civilians who have been involved in these various protests, you know, if the civilian, if there was a decision to charge these people with something very serious, I don't even know if in Canada we have something like sedition, but let's say something like that. And those people were charged with that. I'm trying to get this concept in my head in terms of punishments and equal punishments. You know, if somebody who was involved, who was a military member and was supporting the same activity, would they be subject to the same sort of punishments that a person who's a civilian, who's perhaps charged and convicted of those kinds of serious crimes? I mean, is there any possibility that you'd end up with two different outcomes because one is charged by the civilian courts and one is charged by the military system?
So I can start by kind of briefly addressing the question, then I'll turn it over to you, Rory. But there are sentencing principles that judges have to take into account when they are sentencing people who have been convicted. And they differ in the military context when you compare that to the civilian context. So for example, I'm not going to list them all, but some of the general principles that civilian justices have to take into account: deterrence, denunciation, rehabilitation. In the military context, a lot of those principles are the same. That's true. But there's the added caveat that there are specific military sentencing principles that military judges have to consider, such as the good order, for example, of the Canadian Armed Forces, operational effectiveness, things like this. And so it is possible that depending on how you shunted a case into one of the two systems, you would get a slightly different, at least, sentence between the two.
So to carry on, Dan, from what Preston said, so yes, we do have an offense of sedition for civilians under the criminal code. It's section 59. You will not see it charged very frequently, right? Because sedition requires advocacy for change of government by force of arms. And we're not just talking about some crackpot putting up a video. We're talking about a deliberate effort to try and change government by force of arms. There's an equivalent offense under the Code of Service Discipline at section 82 of the National Defense Act. So even though, as Preston explained with respect to Stillman, paragraph 130 sub 1 sub A of the National Defense Act allows us to incorporate in the Code of Service Discipline criminal offenses like sedition under section 59. The Code of Service Discipline has its own version of sedition under section 82. If that were warranted, and I haven't seen evidence that it is yet, but if it were warranted, it would be charged under section 82. So you've got two different offenses, because a member of the armed forces who's prosecuted under the Code of Service Discipline would be prosecuted under section 82, whereas a civilian would be prosecuted before a civil court of criminal jurisdiction under section 59 of the criminal code. And because we are not in martial law, civilians would not be tried under the Code of Service Discipline. In the case that Preston had mentioned, arising in the United Kingdom with Martin, the reason why a civilian, essentially a dependent of a member of the British Armed Forces, was tried by court-martial was because that dependent was resident in Germany at the time, because his father was a member of the British Armed Forces. And under the Status of Forces Agreement, the United Kingdom could maintain disciplinary jurisdiction over that basically a minor. Because I believe, if I'm not mistaken, Preston, he was a minor child too, wasn't he? He was 17.
Right.
Yeah. So, and in fact, the alternative to being tried by court-martial would have been tried by the German authorities, right? Which, frankly, I think it was better that he was tried by his own country.
Yeah.
But since we're not in martial law, no civilian would be tried by court-martial. So is there a possibility that you get two different sentences? Absolutely. But again, as Preston mentioned, both courts-martial and civilian courts of criminal jurisdiction have very similar sentencing principles. What changes, and the basis for why the punishment might be different, is the context, and most specifically, the context of the offender. So if you have a civilian convicted of sedition before a civilian court, and a member of the armed forces convicted under section 82 by court-martial, you're dealing with something that is arguably, objectively more serious, because it's one thing when a civilian calls for the change of government by force of arms. It's quite something else if a member of the armed forces who's there to protect the country is doing the same thing. So it's not a flaw in the system. It is an acknowledgement of the complexity and the versatility of both the civilian criminal justice system as well as the court-martial process.
I just brought that up because I think these are questions that are swirling around in the news. They're swirling around in people's minds, and we're trying to make sense of all these things, because these are, for most people in Canada, these are not issues that we've had to deal with anytime recently, for sure. Right. So let me start to wrap this up. First of all, as I usually do, and as I need to do, I want to thank several people because these relatively simple-looking events do not happen by sheer magic. In spite of the fact, as I mentioned earlier, by the time we get really good at these things, we won't need to do them anymore, although we might actually want to do them, because one of the advantages that we have experienced over the last couple of years is that we can invite people from all over the country, and indeed from all over the world, to participate in our discussions. So having said that, these things happen not by magic, but by hard work by people such as Sylvia Lau, by Thanuja, by Margit, both who were participating tonight and helping us with the technical side of this, by my colleague Eric Morse, who's the Director of Communications, or Chief of Communications for the RCMI, and who's very involved in the marketing of all of these events. Obviously, I need to thank Rory and Preston for their participation. I wish that our other speaker could also have attended, and perhaps that will happen in the future. And of course, I need to thank all of you who decided to attend tonight. You know, this is a rather technical subject. We're not all lawyers, but I felt very compelled to deal with this and present this information because it very much links into the discussion we had last month about civilian control of the military. And clearly, the legal dimension of that, which is spelled out in terms of, the kinds of judgments that are made and kinds of legal structures that are at work and play in Canada and elsewhere, are really the sort of the sinews by which the civilian elected officials retain control of the military. So we need to be familiar with those things, even though many of us, who have had military experience and have been commanding officers and have dealt with charges and so on, we sort of just take that for granted and assume that everything is good to go. But it's far, far more complex with that as we get into the kinds of issues that both Preston and Rory presented. I hope that I have learned. I know I have learned a great deal more, and I hope that you have as well. As I also posit, the video for this event will be posted shortly by Eric Morris on our YouTube channel in the next day or so. So if you need to go back and refer to this, or you know of other friends or colleagues who are interested in this subject and were not available to attend this evening, you can always put them onto that, and they will have that opportunity to review it. Well, let me wrap it up by saying thank you so much for your participation tonight. Preston, very, very pleased to meet you. It sounds like you've got a lot of interesting challenges ahead of you. We're going to keep our eyes on you, and we look forward to having you come back and speak to us again in the future. Rory, I know we're going to have you come back and speak to us again in the future, but it's always a pleasure to have you. You provide such an in-depth education to us in a field that we're not experts in, but it's very, very important and relevant to the Canadian Armed Forces and those of us who are very, very intimately interested in that. Thank you both, gentlemen, for your time tonight, and thank you all. And I hope that you have a pleasant week. Thank you, and good night. Take care.
This has been another in our series of webcasts produced by the Royal Canadian Military Institute in Toronto as a public educational service. You can find news of upcoming events and links to our webcast archives at www.rcmi.org. On behalf of the RCMI, this is Eric Morse saying goodbye for now, and thank you for joining us.